All right, welcome everybody. Come on in, take a seat. Even take one of the middle seats if you're having trouble. I assume you guys can hear me. If so, would somebody raise their hand just so you know I feel better? I've learned not to do this because then people will raise their hand just because I raised mine, not because they could hear me. I see people raising their hand. Wonderful. All right, today we have a special presentation. This was a requested, sought after, and that usually means the person that was begging for it isn't here, but I think so, I shouldn't have said that until I checked, but that's all right. More people are coming. And so what I'd like to do is I'd like to start off by introducing Lynn Dang, my favorite title rep from Chicago Title, who's going to tell you what we're doing today. What are we doing today, Lynn?
Well, good afternoon, everyone. Welcome to Chicago Title PowerPoint presentation. So my name is Lynn Dang. I am account executive for the Santa Clara County. My job is basically to provide you with a lot of tools and resources to grow your business. If you grow, I grow. So that's my number one goal. My background, I am a certified appraiser. I did lending for 10 years and I've been in title and escrow for 7. Have a lot of patience with new agents, so don't hesitate to reach out to me with any questions and how I can help you grow your business. With that being said, Melissa is my number 1 escrow officer. She has been in the business for over 20 years, not to give her, she started out when she was 5. So have a lot of knowledge to share with you. You are in a great hands. She is patient, have knowledge, and will walk you through the whole process. But today, we are back by popular demand from all of you that wanted to learn about how to understand and read the preliminary title report. So without further ado, take it away, Melissa.
Hi, good afternoon, everybody, and thanks for joining us. So yes, as Lynn said, I've been doing this for 20 years. I do love to do trainings and love to teach, talk about new buyers and do seminars and things like that. It's a lot of fun. But today we were going to go over the preliminary title report. I've got a slideshow up here. Let Mike know if you can't see anything or you can't hear me very well. I'll try to speak loudly. I want to go over, there's a lot of information in these slides, but my goal today would be for you to get a prelim from whatever for your transaction and be able to kind of flip through it and really look for red flags. Look for things that you need to either reach out to your escrow officer about, go to Mike about and say, hey, what is this? We should look at this. So what is our basic preliminary title report? It's our basic snapshot of the property. Our title department will research the preliminary title reports and they will look for potential issues. They go back, they look at the property from the beginning of when this property was developed. If I talk too fast, I'll miss too much of the slideshow and I won't catch up. Again, it's preliminary, meaning that we're not guaranteeing that we can ever issue title insurance. The ultimate goal of a title insurance company is to issue title insurance on a transaction. So we want to be able to issue an owner's policy to that new buyer to say, hey, this is your home, you own this home, there's not going to be any potential implications coming from previous owners. Again, it's important for all parties to review the prelim. A lot of times if you're a buyer's agent, escrow is going to be open up somewhere else. So you're going to get the title report. You'll need to sit down and you'll need to look at it. When you have buyers that are potentially looking at the property, you want to make sure that they're reviewing the prelim too. There's 2 types of policies. So as if you are a listing agent and you've got a listing, depending on what county you're in, your seller is going to purchase an owner's title insurance policy. That policy is going to be given to the new buyer. If you're a buyer's agent, again, your seller, depending on what county you're in, customary closing costs will apply, but an owner's policy will be provided to you. That policy is going to be good for as long as the buyer owns the property. There are some issuance where the policy may get voided if you add somebody to title or you remove somebody. That might change the effect of the owner's policy, but this policy is going to be theirs. And if you think of insurance and you look at insurance as a whole, your car insurance, your homeowner's insurance, they all protect you against future problems. If you get in a car accident and your house burns down, your policy protects you of that. Owner's title insurance protects you against the things in the past, things from previous owners, things from previous lenders or contractors, things like that. There's going to be a lot of different things that can affect you as an owner of a property. The second type of policy is a lender's title insurance policy. So as a new buyer, you're buying your property, you need to secure a loan to get this property. The lender is going to want some kind of insurance for them. If they're going to give up $500,000 or whatever the loan amount is to help you purchase this property, they want to make sure that they're insured, that their claim against the property is insured. So as a title company, when we record that deed of trust to secure the loan against the property, we're going to, in exchange, give them a title policy that says, hey, yes, we just transferred this property to Johnny Buyer. He is in fact the owner. Their property taxes are clear. Any previous liens that were on the property have been paid in full, that will be removed, and that your loan is secure. So the things that are covered on a title report is the estate, which is the property address. So obviously when you ask me to run a title report, I need a property address. That's going to be the most important thing. Who owns this property? You want to make sure that if you decided the seller is going to sell 1235 Mary Lane, that Tommy Buyer is the actual owner. That's most important part. The parcel of land involved, that's your parcel number. That's how the county references the property. Remember, property addresses actually can always be changed and are subject to change. So the county really knows the property by the assessor's parcel number. It's going to show exceptions, liens, encumbrances that will not be insured on the policy. So these things are, it's going to give you a snapshot of different liens that might be on the property, things that we will not insure. And again, it also shows a copy of the assessor's parcel map. So where the property is located as far as streets, shows you different easements and things that are on the property. When you first get your prelim, this is going to be the standard cover page. And this cover page is just our boilerplate legal jargon. It says that we make no guarantee that we can insure this property. You've asked for a title report for this property. This is the report. These are the items that we found on the report. And whether or not we can insure it will depend on whether or not we can address certain items that may or may not be on the preliminary title report. This is what I call our official page 1. This is the page that's going to give you all of the basic information from what you've requested. It's always going to say what title company it is. It's going to tell you who our title officers are, who our escrow officers are. Those are important. As a side note, make sure that you note that there is a difference between a title number and an escrow number. If so I'm here in Santa Clara County. If you say, Melissa, I have a listing in Fremont, can you get me a prelim? The prelim is actually going to show a title number for my county in Alameda, and it's going to show my escrow number. My escrow number is the number that I know. So if you call me and say, Melissa, I want to talk to you about 1234 First Street and title number, I won't be able to search it by the title number. I'll have to reference my escrow number. So just note that if you're calling your escrow officer, try to remember to reference the escrow number. And then again, most important, you want to make sure the property address is correct. Sometimes in our system, if I type in 12345 West First Street and I spell First Street wrong, the examiners may not catch that. So you want to be careful and look and review to make sure that that is the correct property address. If there's a unit number, you need to let us know that needs to be on there because it could potentially affect the lender moving forward. The effective date is basically our plant date. That's the date that the information is good to. Our title plants aren't always up to date as far as what happened 24 hours ago. So the effective date shows when as the most current information is available. This is the type of policy that we're going to issue. Again, there's a couple different title policies that are offered. Our Alta homeowners policy is our most popular. It gives the most coverage and protection for your buyers, as well as the lenders. And that's typically what we go through, or what we use, excuse me. This I want you to look at when it talks about the estate or interest. 90% of single family residents are called fee simple. So that just means that it's a single family residence. Also note that a townhouse or a planned unit development is the same as a single family because they own the land that the house is sitting on. The only variance you're going to see here is if it says condo. That's going to indicate to you that this is a condominium, and it's going to mean that there's probably an HOA involved in the property. An HOA means, where are the HOA documents? If you're the listing agent, then we need to talk with Escrow and we need to order them. If you're a buyer's agent, then you want to make sure that you talk to your listing agent to say, hey, do you have the HOA docs? Vesting. So I want you to also look at this because this is who the owners of the property are. If you're working with somebody and John and Linda are not who you're working with, or you're working with John and Mary, you want to ask, how does Mary fit into this if she's not a vested owner? This is going to tell you how they're holding title. So John and Linda are currently in their trust. Your legal description. So remember when I said that property addresses aren't necessarily insurable? It's because the county knows you by your parcel number. That's the lot and tract and where you're at in the maps. That's the definitive of where this property is and who this property is. Again, we talked about escrow numbers and title officers. Page 2 is kind of like the meat and bones of the preliminary title report. This is the part where you want to look at. So once you've gotten to the official page 1, you want to check the vesting and the property address, flip over. We want to look at this. So property taxes are always going to be there. Property tax is the only thing above any lender or tax lien or anything else that has first priority in the property. So if you don't pay your property taxes, the county will take over the property. So this is showing, excuse me, this presentation is a little older, but it's showing that the property taxes are not yet due and payable. Item number 2 is showing for the current tax bill, what's open, what's been paid, what hasn't been paid. This is important because these are items that we have to address. So depending on where we are in the year, currently right now we're in February, second installment of property taxes are due in March, delinquent in April. So if you were looking at this prelim today, we'd say, uh-oh, this seller hasn't paid either one of their installments. So we're gonna need to include that in the cost breakdown of what needs to be paid. Their sales price minus their taxes minus any liens and encumbrances. So that's going to affect their bottom line. This says, uh-oh, they didn't pay their taxes from the previous year. So again, all taxes must be dealt with in closing. While we're in this transaction, any taxes not paid need to be paid. This is a general exception that says, hey, if there are, when you purchase a property, let me back up. When you purchase a property, your taxes are based on what the current seller's taxes are. After you purchase the property, the assessor's office of the tax collector will reassess the property. And since the bill's already come out, then the reassessment will be a supplemental bill. And that's going to be the difference between what the seller paid as their property taxes and what your new buyer is going to pay for their new taxes. This particular exception is saying that if there are any supplemental taxes, we did not find any. That doesn't mean that there aren't supplemental taxes to come. So if your seller said, you know, I just bought this house 8 months ago and we're already ready to move, whether we're getting a job transfer or whatever else, again, keep in mind that there might be a supplemental tax bill. That tax bill is always going to be their responsibility. So they may, even after they sell the property, the county might catch up and say, hey, this is a supplemental bill for the 8 months that you own the property. You're going to need to pay it. A Melrose, so we all know with your property taxes, you're not just paying property taxes. We vote on different things during the year that says, you know, we want better schools, we want better water service, we want, you know, mosquito protection. Melrose is like that. It's typically for libraries, for different community services, and they will vote on a bill and then they'll tax a certain area. And that gets built into your property tax bill. CCNRs, 90% of most tract homes have CCNRs. These are covenants, conditions, and restrictions. They basically say what the property is used for. Most newer developments within the last 20 years are just talk about streets, sidewalk maintenance, things like that. Older homes, homes that have been established for 20 plus years, some of those things may not even be valid anymore that are on there. They'll talk about things like raising livestock or having chickens. You know, if you've got a dock, or there used to be a creek there, they may have information. Some of it isn't pertinent anymore. So again, 90% of properties have easements. Easements are public utility, PG&E and water. They have their equipment that runs underneath your house and through your home. So they have to have access to the equipment that runs through your home. If, you know, again, we all heard about PG&E and, you know, blowing up in San Bruno. So again, if they needed to come out and repair gas lines, those gas lines may come through your property. They would have to contact you, make arrangements, and they have access to their property or to their product. Deeds of trust. This is one I want you to pay attention to. I want you to look at the different deeds of trust that are on the property. This particular property only has one. That means they only have one mortgage. But you may find a prelim that has 2 or 3 of them. And that's a red flag. That's something, you know, it's common for somebody to have a first and second mortgage. It's not, it gets less and less common as the more mortgages go on. And you want to look at that. And then you want to go back and ask your client, hey, there's a couple of different mortgages showing on the property. Are all three of these active, or are all these loans active? We want to make sure that we address that early. If there was an old loan, say the client in 2004 or 2000 got a loan with World Savings or Downey Savings, which I happen to have right now, and that loan got paid off, but in the interim, maybe the company closed down, they went bankrupt, they went out of business, that loan didn't get removed from the property. We need to start that research, and we need to start it sooner than later, because it could take anywhere from 2 to 4 weeks to get that information, to get it removed. And remember, this is a snapshot of what's on the property. We can't insure it if we can't promise that we can get rid of some of the items that are not supposed to be there. Solar, again, you want to look for this, because as a listing agent or even a buyer's agent, if there's solar, we need to reach out to the solar company and start the transfer process. So when you have a solar system, whether it's leased or owned outright, you need to contact the solar company and say, hey, I'm selling the property. I'm going to be giving it to somebody else. We're in contract. What are the steps that are needed? Depending on whether it's leased or owned, it will depict what exactly we need to do. But typically speaking, there'll be a transfer agreement that the solar company will put together, and they will email to the seller, to the buyer, via DocuSign typically. They'll sign it, and if there's any items on our prelims, like this particular one, this finance statement here, that actually has to be removed. The solar company will provide the title company with a document that gets recorded with the county, and it'll remove this finance statement. And that we'll need to get that prior to closing. So again, the sooner we start that process, the quicker we can have it done, because it will delay the closing. This one, let me see if I can go back. This solar notification here, this is kind of like an easement, like item number 7 and 8. It's saying that yes, there is solar. The solar company does have their particular product on this property, and if they need to come out to service their product, they have the right to access the property. So remember when we were looking at who the owners of the property were, and it's John and Linda, and they had a trust? Anytime we have somebody that's in a trust, we need to verify that they have the ability and the capacity to sign on behalf of the trust. This is a particular notice that's saying we're going to have them fill out a trust certification. So again, they're going to sign under penalty and perjury in front of a notary, saying, yes, I am the trustees of the trust. I have the authorization to sign on the trust. Now, when I was saying it was John and Mary or Maria, and you asked, well, who's Maria? Well, Maria's John's daughter because Linda passed away. Okay, well, if Linda passed away, then you need to notify your escrow officer right away, because we do need to address that. It's no longer John and Linda's trust. It's John who's the successor trustee of the trust. There's going to be different documentation we'll need to prepare. We'll have to discuss that. And escrow, obviously your escrow officer can help you facilitate those items. And if somebody in your trust has passed away, one of your clients, typically title's always going to want to see a full copy of the trust. And if I can ask for a favor to please not piecemeal the trust, just send us a full copy. Bring the whole binder down and let us copy it for you. There's, our title officers are very particular about reviewing the full trust to make sure. They want to read what happens when a trustee passes away. What does the trust say that needs to be done? Who is the successor trustees? Are there one? Are there multiple? I had a just last week, I had a file. There were two people on title. They were not in a trust. One was an unmarried man, the other was an unmarried woman, and the unmarried man had passed away. Typically, we would do an affidavit of death. It would move on to the unmarried woman. These people, however, didn't have a vesting. So it didn't say as joint tenants or as tenants in common. And now, not only can we not move forward with the transaction, but the client actually has to go and hire a probate attorney. And they have to get somebody, they have to go to court and have the court designate an administrator for that person so that we can then turn around and transfer title and insure it correctly. It takes a lot of time, it's costly, and it's a little discerning for them. Our note section, these are different items for us, usually for title they want us to look at. They want to make sure that we've checked the other requirements. It'll give specific information. If you wanted to know, look at item number 5. That's our most common question that people ask, or that lenders are going to ask. They say, we want a prelim with a 24-month chain of title. Item number 5 says that there are no deeds affecting this property within 24 months. So that means that there hasn't been any transfers of title. Nobody came into the property, nobody came off the property. If there were different transfers, if, for example, when John and Linda came into their trust, say they did it 6 months ago, it would show in this particular section. The other one to point out is item number 7. Item number 7 will indicate the type of property this is. So if there's ever a question, if somebody's questioning you whether this is a condo or if this is a single family resident or if this is a PUD, which is a planned unit development rider, look in the note section of the prelim, because it's always going to tell you that this is not, that the company is not aware in which any manner is asked to decline to attach a CLT endorsement. And it says the said land, a single family residence. So again, the definition of a single family residence is a residence that is sitting on a piece of land that is also owned. So any a townhome and a single family resident are one and the same. The only difference is when it talks about a condominium or multifamily. If it's one building with 4 units, it will state that in that particular section. This is your plat map. This is again how the assessor's parcel number is comprised of. It tells you what the book and page number is, where it shows you a picture that it'll say PIQ, so property in question is usually what it says. That's the definition of that. We have a lot of different things that would cause us to deny a transaction. Most commonly is fraud. Obviously, if somebody has impersonated somebody else, they said, oh yeah, I'm Sally and I own this property. We have had incidents where somebody's been deathly ill on their deathbed, and they got a notary to come out and notarize their signature where they may not be of sound mind, and they've transferred their property to someone else. I had a property where a gentleman knew he was going to pass away. He was ill. He signed a transfer of deed upon death to his mom. And so when he passed away, the house automatically transferred over to his mom. But again, from an insurance company standpoint, from an escrow point, we have to ask those questions. What was his state of mind when he signed this form? Was he married? Did he have children? How do we know that he really wanted mom to have it? So those are the kind of things that we don't always know. We do ask the question. So documents that get recorded, if the legal description is wrong on a document, it'll get recorded against a different property. So let's just say I had a property and I wanted to give 10% of the property to my son. And when we recorded it, we recorded the wrong legal description. So it went on to somebody else's property. And I pass away, the property gets sold, and then my son comes back and says, hey, wait a minute, my mom signed a deed giving me 10% of the property. That would be a title issue. That would be something that, my son could go to the title company and say, look, maybe it was recorded under the wrong legal description, but it was my mom's intent to give me 10%. That would be something that would be an issue. Misinterpretation of wills. We don't really look at wills. We'll look at trusts, and we'll look at what's within a trust, not so much wills. Deeds by minors are a pain, and nobody should ever deed a property to a minor. A deed by a person supposedly single. So California is a community property state, which means that it's automatically community property when you get married. If you signed a deed, if I decided to buy my house and said, oh yeah, I'm a single woman, but I'm really married, and then I decide to sell the house, my husband can say, wait a minute, this is a community property state. She bought this property when we were legally married, and I'm entitled to half of it. That's a problem if somebody is forging or falsifying information on their recorded documents. That's fraud. Building violations, subdivisions, typically those are usually going to show on our prelim. If you built an ADU and you didn't get the proper permits, the city or the county will come out and put a violation on the property. If you weren't taking care of your yard and it was causing a nuisance and the city had to come out and clean your yard for you or remove that car that's sitting on your front lawn, they're going to put a violation on the property, and that's going to need to be taken care of. That costs money for the city, for the county. They're going to want their money back. Zoning laws and encroachment protection. Again, some of the older properties that have been around for a long time, maybe 50 years ago, there was a set of neighbors that said, hey, I realize you have to cut through my property to get to the creek for this. So let's do an easement or an encroachment so that you have access to that. A lot of those things end up causing problems because they're old and people don't know. I was talking to our builder services manager this morning, and he was saying that a subdivision built this whole division of homes, and there was an easement that was, 60, 70 years old that they didn't even address when they were building these homes. So now they've got this entire subdivision, and there's an easement running through the whole division that was never addressed. Fortunately, he worked with our title department, and our managers were able to come to a conclusion with it. But I had an issue with another title company. I was going to do the refinance. When the people purchased the property, there was an easement for an old well that wasn't even being used, but nonetheless, it's an easement that was there for ownership. The title company had mentioned both parcel numbers on the face of the grant deed, but when they attached the legal description to it, it should have had the legal description with both APNs, meaning that the property and the building that it was on, as well as the well. Well, when the document got recorded and ownership was transferred, that legal description was wrong. So then we go to open up the refinance, because now the clients bought their money, they bought their home, and now they want to refinance their loan. And title's reviewing it, and they said, Melissa, we can't insure this. We've looked at it, and we don't know what the intent was. It looked like the cover page of the deed of trust mentioned both parcels, meaning the house and the well, but the legal description when it recorded didn't include the well. And so the well is still technically in a previous owner's name, that easement. So I had to talk to the clients and their loan agent. We decided we'd refer the transaction back to that original title company, because essentially they're going to have to get the original owners back into the office to have them execute a new grant deed, attach the correct legal description, and re-record it with the county to move forward and so to clean it up. So in short, again, our title policy is just a snapshot of the property. What I really want you guys to look at is I want you to check that official page 1. I want you to look at the property address. I want you to look at the owners. I want you to flip to page 2. And I want you to look for things like multiple deeds of trust. I want you to look for anything that says a franchise tax board lien or a state tax lien. Again, those are the items that you need. I have my cheat sheet here of things that we should look out for. Court orders, judgments. When you're meeting with clients and, ask Lynn or I for a property profile so we can verify upfront who the owners are. We can tell you, okay, here's the property profile, here's the vesting deed, this is who you should be signing, your listing agreement. If there's anybody else involved, that's an immediate, who is this person? How do they pertain to this transaction? If, Linda's not available, why isn't Linda available? If she's passed away, again, how did you hold title? Because there could be probate involved. If you're in a trust, do you have a copy of your trust? I actually had a sale. The husband was out of the country. I can't say for sure, but I'm pretty sure husband and wife were estranged. They had recorded their property in trust. She had no idea who her trust attorney was. She had no idea where a copy of the trust was. She had nothing. We had to go through so many different hoops and circles to track this information down and get it, because she just didn't know. And, thankfully, again, the listing agent was asking, do you have a copy of your trust? Husband's out of the country. They wanted to sign a power of attorney, but we can't determine if you can use a power of attorney until we see if the trust allows the power of attorney. So you can see where not having a copy of the trust would be a problem. So those are the kind of questions you really want to ask when you're meeting with your clients and looking at doing different listings. If you guys have any other questions or concerns, Mike, did you have anything you wanted to share?
Hello, Mike.
You're waking me up. That's,
Wait a second.
I was reading all the questions.
Not that boring.
I know, I'm just kidding, reading all the questions. So, the most obvious thing is I get agents that, want me to help them with their reading disclosures and things like that. And you went over what to look for in the prelim. One of the things that I would suggest, and this, this has only happened to me once, but it was sometimes there's a link to the deed, like a hyperlink. And so we had listed a house and got a prelim, and the agent that I was working with is very meticulous, but the link to the deed she did not click on. And later she asked me if I usually clicked on those and read them, and the answer is no, but now I do. And so what happened is that if you clicked on the link, what you would have seen was that the deed that the seller had received the property had been purchased through one of the housing trusts. And there's two housing trusts in our area. One is the Santa Clara County Housing Trust, the other one is the Silicon Valley Housing Trust. And one of the housing trusts, the guy had owned the property for like 20 some years. And one of the housing trusts, after 20 some years, you can do whatever you want. And the other housing trust, you can't ever do what you want. And it happened to be this housing trust. And in other words, what that meant is because the housing trust had helped them buy it over 20 years ago, they were not allowed to sell it to whoever they wanted to. They had to sell it back to the housing trust, right, for not very much money. And so that's the only time I've actually had to read a deed. But normally, is that something, now I look, right, just to see if the deed looks funny. Because if you look at the deed, you could see the deed was from the housing trust, and it mentioned in the deed that there were restrictions on the person's ability to sell the property in the future.
Yeah, and that's, and BMRs you have to look out for too. Some BMRs, again, they have to be owned for a certain amount of time before you can outright sell it. Otherwise, you have to turn around and sell it to somebody else. When I say BMR, it means below market rate.
Yeah.
It means low income housing. So those are different things.
And there's the BMV, the below market value. There's one of those for sale in Morgan Hill, and I get agents always calling me up because it sounds too good to be true. And it is too good to be true, right? And in fact, I've been asked questions about down payment assistance programs, and some of those involve below market value. There are restrictions on your ability to. Is there anything else that, I click on the deed now simply because I was burned once for not. Is there anything else that, like exceptions, is a question? You guys can see the questions, can't you, Lynn?
No, I cannot.
I don't see it.
All right, well, you both have the authority to look at questions in your panel. So the first one is a comment. Love Chicago Title. They have the best website and resources. I opened Escrow with them this morning. I replied, I hope you opened with Lien, and the person left the meeting. So I don't know. That's probably a no. I'm sure those two weren't related. Somebody asked about it being recorded. I answered that. Would you reshare the presentation? I told them they had to talk to Lynn if they wanted to get a copy of the presentation. Is that correct? Yes.
Yes.
Then there's another reminder that guy's left. So the question was, the seller has the report in their disclosure package. And if you're in Silicon Valley and it's a typical sale, you'll probably get a copy of the prelim. And if you're not in Silicon Valley, they may or may not have a disclosure package with the prelim. The one thing I would mention about that is if you're an agent, and because agents ask me, well, how do I know who they've opened escrow with? And so my answer is, did the seller listing agent provide a prelim? And if the answer is yes, go look at the prelim, because in the first page of that prelim, the first real page, it'll tell you who the escrow officer is and the name of the company and their email and their phone number and all of that. Unless this is requested by the buyer's agent, the report is not sent. This is usually, you guys go ahead. I'm not going to answer all your questions, but who usually orders and sends the prelim?
So again, it depends. If you're a listing agent, then you open the escrow. I will send the prelim to you and your assistant or your team, whomever you choose to. If you're a buyer's agent, and hopefully my listing agent has sent me the contract and all your information is complete on the contract, I will send you also, whether you've got it, you've received it or not, a copy of the prelim to say, okay, thank you, welcome aboard. Looking forward to working with you. Attached is the prelim, and any other information you need, please let me know.
And if you're representing a buyer and there's a lender involved, what does the lender want? The answer is a copy of the purchase agreement, counteroffers, and addendums attached to the purchase agreement. They do not want to see inspections and reports and things like that, unless it's an FHA or VA, but just don't, have them ask. And they want a copy of the prelim. Right. And so if you represent a buyer and you're in escrow, you need to make sure the loan agent gets that information. And then the loan agent will know who the escrow officer is and all of that. Lori asks, what happens if a client only wants to provide certification and not the entire trust?
It depends. Under most normal circumstances, if the two sellers, husband and wife, have their trust and they're the trustees of the trust, 80% of the time, we can just do the trust certification and not move forward. Our prelim does not always ask for a full copy of the trust. And again, if it's just a cookie cutter trust, husband and wife, trustees of their trust, and everybody's, husband and wife are still alive, typically the trust certification is fine.
And my suggestion, if you're a listing agent, it involves a trust. And there are two kinds of trusts. There are living trusts and
revocable. They're revocable.
I was going to call it a dead trust, but that's probably an inappropriate way of putting it. So if it's a living trust, which means it's a family trust, which means it's an inter vivos trust, which means while a living trust, then it's handled like a regular transaction. And if it's somebody's died, then it's a vested trust, which that's my term for it, but it's a little more complicated. And so my suggestion, if you're the listing agent, is that you have the seller speak directly to your escrow company about the kind of trust they have and to give the documents and not be an intermediary, right, translating back and forth. That's just my thought. If a person only has a will and not a trust, what happens?
You're still subject to probate,
right.
Unfortunately.
Yep.
So the difference, by the way, is that if there is a will and probate, it means there's a lawyer and a court. And so it's very different. If it's a trust, it doesn't necessarily mean a lawyer and a court, but it could mean a lawyer and a court if there are people complaining about the trust. What should the buyer be concerned with exceptions?
Yes, so they need to look at easements. Again, as I was stating, like the encroachment, if, 50 years ago, the neighbors decided that they'll have access, and you as a buyer, you're looking at purchasing this property and you want to remodel because you're into feng shui and you're going to turn the whole house 180 degrees or move it back, and your neighbor says, hey, wait a minute, I have access through this property. If you build your house there, I no longer have access per the agreement 60 years ago. You would want to look at that. You would want to know that. When you were asking about easements, I've thought about it. There's different programs that you can get through the county to upgrade your home, whether you upgrade your windows or you upgrade your solar. You can get solar and things like that. And what you'll do is you'll get a loan, and that loan will be paid through your property taxes. It's still owed to or due. You still have to pay for it, but you need to know that if you're a listing agent or if you're a buyer's agent, because you don't want to get stuck paying that bill for the improvements. The seller chose to get a loan and seller chose to do the improvements. So that needs to be ordered and paid for at the time of closing.
Sure, and also I look at the exceptions because I've had transactions where it usually involves easements, right? And there was one we did in Walnut Creek where there was a 25-foot easement, maybe not, right? And what was weird is that the city had actually redrawn the map without being asked, which has not been my normal experience. And the title company basically was saying, we're not going to do any of this. We're not covering the easement because this is crazy. And, that's exempted from our coverage on the title policy, which, hours, 6 months later, and lawyers. When do you recommend requesting the title report? Right after you call Lien and open escrow.
Yep.
Is that a good answer, Lien?
Yes.
You want it soon, because sometimes I listed some land in Redwood City. I got a prelim and it was clean, looked like a whole bunch of other ones. And then the title company called me in a couple of weeks because they found a judgment against the guy. Right. And so judgments like this was, he'd been sued in San Diego 5 years before, kind of a judgment by a business partner. And it didn't show up on the prelim, right? Because it was a judgment against him and not on the property, but eventually they found it. And so my suggestion, you would like this to start percolating, you know, as soon as possible, right? So that,
Right, if I can also add, typically if the property is located in Santa Clara County, getting the preliminary title report is pretty quick. If it's out of county, sometimes it takes maybe an extra 1 to 2 days, possibly, depending on the volume. So keep that in mind also, but the sooner the better, because especially now property sells so quick that as soon as you have it, then, you know, you can share that with your potential buyers.
so what happens, this is a Mario question, when a lien owner cannot be found, what can the title company do to clear the lien?
Oh, that's a tough one. I actually had one. Somebody had passed away again, and 100 years ago, they got a loan for $20,000. I Googled and Googled and searched. I was finally able to track them down. But if a lien holder cannot be found, then we need to utilize a bonding company, somebody that will bond around that lien. You'll pay a percentage of the lien to the bond company, and they will do the work as far as posting to different news outlets to find out if there's any errors. They'll do the work. But it's the only way to get around if somebody's passed away or if you can't locate someone.
Yeah. The title company doesn't have the special powers to make liens disappear on their own, I think is
I wish.
Well, as you know, right, our job is to make sure that we clear all liens and hand over a clean title to the buyer. So we're here to protect the buyers as well. So of course, if there's something on there is unanswered, we will not give you a title policy.
Right. So does the title company point out issues to the buyer's agent or buyer, I would throw in?
Typically, it depends on what the situation is. I had a property up in Oakland. There was some whispers on the listing agent side that there might be a mechanics lien. And I did mention it to the buyer's agent. I said, I'm going to have my prelim updated, because if there is a mechanics lien, that's going to put a big stop on the property, because we're going to need to get that issued. Most items on the prelim tend to be more geared towards the owner of the property and things that we need to clear. If it's something that's going to take some time, I do tell my buyer's agent, because I want them to be aware and I want to set the right expectations for time frames.
There's a question about, did you say all liens are shown and should be cleared before the transfer of title? Is that part of title insurance for the new owner?
Yes.
Yes.
Now, there are some, like Melrose and some things that you buy subject to.
Correct. But most, we're talking about mortgages, tax liens, mechanics liens, state and federal liens, child support liens.
Right. But there's some, like a Melrose and some special assessments that don't go and cannot pay off. So there's when would you request a property profile versus a prelim? And I think there's a follow-up about when would I want a property profile?
If you're going to do a meeting, if I have a lot of clients that say, I have a listing appointment, can you provide me with a property profile and the current deeds? Because they want to see, again, they want to see the property profile. They want to see who and verify who it is that they're supposed to be meeting with to discuss this property.
Right. And
so by the way, if I can follow Melissa or piggyback to what she said, so property profiles, we will give you access to it if you reach out to me, and I can sign you up, and then you can have access to property profiles. Okay, it's free of charge. If we are going to partner together, then that's one of the ways for you to get all that resources available for you so you can do your business. Now, if you have a listing agreement, then yes, we would love to have that opportunity to service you and your client, and we will open the escrow and we will order the preliminary title report. Now, sometimes if you have a rush situation, we have cases where an agent meeting the client on a Friday and Friday morning, whatnot, and they sign the listing agreement and they want to go on the market over the weekend. So let us know, and we can certainly request for a rush, and sometimes we can fulfill that request. So just let us know what you're looking for.
I was going to suggest that if they wanted a property profile to talk to you also, Lynn, that they could. So a property profile you could run immediately and print out, and it would tell you who's the most obvious owner, what the tax assessor thinks about the property, the zoning of the property, and other useful information. I'm going to answer a couple of them. Do you need an RLA for the title report? The answer is no. Nobody sees the residential listing agreement but you, your client, and your broker, right? The escrow company doesn't want to see the listing agreement. The lender doesn't want to see a listing agreement. Nobody wants to see the listing agreement, right? Is that right? I've never had the title company ask for a listing agreement. But I guess you could if there was a dispute over commission, but other than that, I can't think of why.
Well, you know, it takes a lot to put a preliminary title report together. We usually, majority of the time, we don't ask for it, but some cases we do. Because say if I have a particular agent that open escrow and get prelim 10 times and never close the escrow.
Right.
So the next time that person asks, I will ask to provide me a listing agreement.
That's why I don't do that anymore. Yeah, it costs money, and technically you guys could charge for it if you were.
Exactly.
So there was a question about would you take it with you on a listing appointment? The answer is no, right? Because you don't have a listing. If you're going to take something on the listing, print out RPR, right? RPR has a summary of a lot of the information that's on the property profile. It says under Schedule C, deed of trust, if there is a divorce cause, does this mean both parties have to sign to transfer ownership?
Well, that depends. If they're in the preliminary stage of the divorce or they've gone to an attorney, the judge has already ordered and said, okay, Johnny, you get the house, Sally, you have to quit claim off. If there's already an agreement signed by the court, we have to follow that.
Right. And if both people are on title, you're going to need both signatures or something from a court telling, Mary would like you to explain a mechanic's lien. I guess that's when your car breaks down and you.
Exactly. Gotta pay the tow truck driver.
Landscaper, remodeling,
I should say
kitchen.
marketing. So let me do this quickly, if that's okay. The California state constitution says that if a work of improvement is conducted on real property and the person providing the service materials, including people that deliver lumber, including PG&E that has the power, anybody that worked on the property, that they can file a mechanic's lien within a certain period of time after the completion. And if there's one of those, then it needs to be removed, right? So if work is being done on the property right now, and the title company found out about it, does that concern the title company about issuing title insurance because of the way mechanics liens, when recorded, take effect?
Depends on the scope of work that's been done. Obviously, you're going to do some work to get or most people are going to do work to get the house ready, whether they got new floors and painted cabinets and things like that. Usually, that's the first question I'll ask you is what is the scope of work and what is the cost breakdown? I'll ask underwriting, and then they'll say, oh, yes, we want what we call indemnity approval. So we'll ask our owner to sign an indemnity agreement indemnifying Chicago Title of any potential tax liens or mechanics liens, excuse me.
And if it was a fix and flip, then that would be a
Again,
bigger-
it depends on the scope of work. A lot of my flippers do have to prepare and provide the indemnity package.
Did you want to add anything else about a mechanics lien? Because
No, I think you
was that
were great.
if an item was probably paid off, but the seller does not have proof of payment.
So that would be where we would try to track down a reconveyance. So once a mortgage is paid in full, that mortgage company is responsible for preparing and recording a reconveyance. The reconveyance actually removes that deed of trust from the county records.
Okay. How the title company execute the reconveyance? I think the answer to that is the title company doesn't execute in the sense of signing, but if you're talking about recording, you know, I'm not sure.
Or assisting with tracking down the parties that need to
Or
have it
recording. The deed of reconveyance is issued by the trustee back to the original borrower, the trustor, when the lien is paid off. And the trustee is the one that would sign that, I think, right?
Yes.
What if a lien was discovered after transfer of title? Is it covered by the owner's title insurance?
Yes. And that would be the importance of title insurance.
If it was something that happened prior, if it was a lien that was created prior to the conveyance.
Correct.
Right, not afterwards. So in one way I explain title insurance is, and maybe I'm wrong, this is the chance for me to find out, is that what makes title insurance different from most insurance is that most insurance, you buy fire insurance against a future fire, right? But you buy title insurance on a past action, right? That there was nothing in the past, in the history, in the chain of title that is an issue, not necessarily protecting you against future things that might apply to the property.
Correct.
No. And is this something that Prince Andrew and Prince Harry should look into, title insurance?
Absolutely.
I couldn't stop myself. Any other questions? We may have exhausted them. So I guess we're going to say thank you for participating in this. If you would like to get some assistance in getting a property profile or getting access to the website where you can get property profiles and other information, reach out to Lynn. If you are opening escrow soon because you have a listing, reach out to Lynn. She can help you with anything involving opening up a listing. Right? And
feel free to reach out to me with if you want to have a meeting or Zoom meeting in person or on Zoom to review your business plan for 2022 and see how I can help you grow your business.
right, and I believe I have pasted into the chat your contact information. I believe I've done that. All right.
Yeah, I saw that.
Cool. All right, so thank you very much. You're distributing documents. We can see your screen. So I'm going to call it an end. All right, there we go.
Mike, thank you for having us. We appreciate you. It's great to have partners like you, so we appreciate you.
All right.
Yes, thank you very much.
All right, goodbye, everybody.
Bye-bye.
Bye, have a great day.